Matter number 2. Do we have parties for matter number 2?
Good day. Good morning.
Good morning, Mr. Ngako. Are you for number 2?
Yes, yes, ma'am.
Okay, do you have your opponents with you, or are you aware if they've joined or not?
Mr. Sneeman is for the applicants. I don't see him.
Okay, I was asking because a judge will start with that matter.
Oh, no, okay.
Do you by any chance have Mr. Sneeman's number that you can assist with?
Okay. Let me just see.
Onisiwe, maybe I could make a suggestion. If Mr. Sneeman is not online, that I hear matter number 1, Mr. Mathe and Hoya Lens South Africa.
Yes.
All right.
Okay.
I think that's an efficient use of our time. Thank you.
Mathe versus Hoya Lens South Africa, case number JR1472 of 2023.
As it pleases the court,
so I can start, my lord, my lady.
Before you do, I would just like to raise with the third respondent, and Mr. Cook, are you acting, or you're on the instructions rather, for the third respondent?
That's correct, my lady.
I don't have your answering affidavit in the review.
My lady,
it's very clear that it was filed. I have approached the registrar's office to see if it's located.
Can I get my instructing attorney who's online to forward you to your secretary a copy of the answering affidavit? I do have a stamped copy in my possession. It was filed, my lady, on the 20th.
See, there's a service affidavit to that effect as well.
Yes.
But if you could make a copy available for me, I would much appreciate
to which, my lady, to which email address would be most efficient?
So I think for present purposes, because I'd like to get a copy ASAP, I would like to suggest it goes to my secretary at my firm, and she is Ilda, ILDA dot LOUW at cdhlegal.com, as well as Millie, MILLIE, Pretorius, she's PRETORIUS at cdhlegal.com.
Thank you. My attorney of record is on record, Mareka. If you could kindly do so. Mareka, is that all right?
My lady, I confirm that I will send same through as soon as possible.
Thank you.
Thank you, my lady.
My lady, I actually have a problem with the answering affidavit, my lady, because it was filed out of time. And I told the respondent in 2023, when they sent it to me, I objected to them. I said, no, this is out of time. I cannot respond to it unless you get condonation. And then at that time, it was only 30 days late. And they said, no, it's not late, it's not late. And then I said I couldn't respond. And then last week, they sent me a condonation application on my email. And then I asked them, did they also file the condonation so that I can oppose it? And then they never got back to me. So when I objected to the answering affidavit, if they did apply for condonation, then I would have addressed it. If it was the condonation was granted, I was going to reply to it. It was late in 2023. And then they sent me a condonation, and their condonation indicates to me that the matter is indeed unopposed. So if my lady accepts that the affidavit is the answering affidavit is before the court, I will also like to exercise my right to reply to the answering affidavit, because since they sent it late and I objected, I never got to respond to it because it was not before the court. And after, when I was at the court to file my objection to the late filed affidavit, when I got to the court, it was not on the record. So I could not file an objection to an answering affidavit that is not filed. So I didn't file it. So last week when they sent me a condonation application, I asked them to confirm, is it filed with the court? Because now I'm busy drafting my opposition for the condonation. So my lord, if this court finds that the answering affidavit is compliant with the rules, even though I disagree, because in 2023, when I made the objection, it was only 80 days late. And when they sent me their condonation, it was over 600, it's over 600 days late. So if it is before the court, I will ask, and then that condonation is granted, I will ask that I'll be given my 5 days to respond.
Right. So, Mr. Mathe, I have before me a condonation application that has been served on the respondents and filed at court. And the filing at court was the 12th of June, 2025. And according to the facts, at best, this matter is 2 court days out of time. You are saying you wish to oppose it. You know, this application can be brought at any stage. There's no rule that says it's got to be brought within X period. It's come to the attention of the third respondent that it would be opportune and possibly wise to at least put in an application for condonation, and that has happened. So you were given an opportunity then to respond to that.
My lady, the condonation application, the answering affidavit, I sent the respondent the supplementary affidavit on the 2nd of August, and then they only served me their answering affidavit on the 14th of November. So if you count the days there, it's over 30 days late, and I think they only had 15 days to answer, and it was over the 15 days.
Right. Now, I hear you on this issue, but you're aware of this application for condonation.
My lady, I am aware of the condonation application. However, I wanted to oppose it. That's why I asked the respondent if it is filed with the court. If they did confirm that it was filed, I was going to reply and then file as well with the court, because their answering affidavit, they said it was not late and they never filed it. And I couldn't object to it because it was not before the court. So I can't keep responding to things that are not on before the court, my lord.
Okay, now, Mr. Mathe, the application has been brought by the third respondent, so I think it's opportune to let their counsel address me on the matter, and you'll have an opportunity to respond. Thank you.
Thank you, my lady. The applicant has not been accurate with the court. Your ladyship will know that there's a service affidavit. This affidavit wasn't served last week. It was served and filed in court on the 12th of June, advising. And the premise for this application, my lady, as you'll see, is out of extreme caution in the event that the court finds that condonation is required. It's not a concession that condonation is required, but the third respondent, in order to progress this matter to finality, out of extreme caution and upon advice from myself, in case this is a hurdle, the application was filed. Now, the facts of the matter, yet again, the applicant is not factually correct about the lateness of the affidavit. What the applicant is, and although he has studied at Wits and professes to have some knowledge of the law, seems to not know the rules of the court, and has flagrantly disregarded the court rules on numerous occasions, despite the kind and patient assistance of my attorney of record, trying to guide him as to the correct processes. And what he did do is prematurely file a supplementary affidavit. And that affidavit was premature because he had not yet, until to date, has not yet filed a complete record in the review. This was pointed out to him that that was an irregular step. And only when he sent the complete record was he entitled to, in terms of the rule, to file the supplementary affidavit. Now, the contentious issue in this regard is the service by way of WeTransfer. Now, what the third respondent's attorney of record did, take into consideration that this individual is a lay person, in order to accommodate them, said, listen, you tried to send us voluminous documents. Why don't you send it through WeTransfer? That was done on the 27th. Now, the fact is that the attorney was not in the offices and only returned after taking leave. And the date on which it was downloaded is, in fact, the date that it was received. And if that is correct, then there is no need for condemnation. But in case the court comes to the conclusion that, well, it was sent through on that date and therefore it came to your attention, which we perceive would be incorrect, but the date that the documents, and it's confirmed in the affidavit, there's in the email, contemporaneous email, I've now downloaded your documents, I'm in possession. That is the correct date on which you should calculate the DAs. If the court accepts that, then there's no need for condemnation. Now, the applicant in this matter says that he doesn't know if there's a condemnation or not, and he can't respond to things that are not before him. The applicant knows about them. There was a service affidavit which your ladyship can find in the index bundle of the condemnation at page 36. So the applicant is misleading the court there. He knows about this condemnation. He's elected not to oppose it. So now, this is the very same applicant that has approached the High Court, my lady, on 2 urgent applications. One's against the CCMA and the Commissioner, alleging fraud and corruption, and then wants them to be investigated by the National Prosecution Authority, and then bringing in another urgent application against the third respondent for payment of damages for he's losing his job and declaring his dismissal unlawful. And in those papers, on the grounds of urgency, continuously says, I want this matter to be heard, but the Labour Court is going to take 2 years. It's going to take 2 years. It's prejudicial. This is the very same applicant that says now he wants to oppose it and then he wants to file replies. In the interest of justice, my lady, he knows, and he's quoted in his other applications, you stand and fall by your founding papers. And in our heads of argument, we also refer to your ladyship to the fact that replying affidavits and even answering affidavits and review application actually carry little value. So in the interest of justice, my lady, we would submit that we've entered into a notice of intention to oppose. If your ladyship wants to say that the condemnation ought to be granted, so be it. But if that derails the matter because the applicant insists on his right to reply, then, my lady, we would make this proposition to your ladyship. That will cause this matter to be delayed unnecessarily. And the reason for delay is because, one, my lady, if there was no need for condemnation, the objection to the late filing is on the applicant, and he's the cause for the matter to be delayed and his failure to file a replying affidavit. If, however, condemnation is required, my lady, and you grant it, and now you insist on right to reply, my lady, we will then, in those circumstances, and subject to my instructing attorney objecting, which I don't think she will, we'll oppose these papers simply on the papers filed, because he does not make out a case in his own papers. And the reason why we do so, and we are confident to do so, is that you'll see from the papers that there simply isn't a case made out. There are generalized accusations, vexatious accusations, unfounded accusations in this matter, and we are prepared to pose this matter merely on the papers of the applicant in this matter. What the applicant seems to believe, or is under the incorrect perception, is that merely because an answering affidavit has found that this matter is not opposed, we have filed a notice of intention to oppose, and he bears the onus to convince this court that the review should be granted, even if there isn't an answering affidavit, my lady. But it's not in the interest of justice, and certainly this court has been burdened with these papers. It's a meritless review application. There is no substance to it, and it needs to be brought to finality.
Well, I was going to mention that if it was the applicant's contention that the third respondent wasn't properly before me, by virtue of no answering affidavit, well, I would have a difficulty with that on the prevailing case law, because I've seen there was a notice of opposition to the review itself. And either the applicant has made the grade on grounds for review or he has not. And that will be something I would need to decide. My thinking, though, is to hear the matter on the merits for one reason only. If there's no basis for condemnation, i.e. there was no reason for the condemnation to be brought, well, then I'm seized of the merits in any event.
I'm in your hands, my lady. What the third respondent wants is an end to this. We want finality. This matter has taken too much time and tension and costs, and a postponement is not in the interest of all the parties, including the applicant, including the court. So we are in your hands, my lady. We clearly make out in the condemnation application that it was done out of extreme caution. But my lady, we submit, and we in our heads of argument stated that there is no need for condemnation, as explained, my lady. The applicant is seizing on technical points and just trying to frustrate the process. Meanwhile, the applicant is the one that out the one corner of the mouth wants his day in court, but does everything to throw technical hurdles in the way of resolving the actual matter on its substance. So, my lady, we are in 100% agreement that this matter must be dealt with on its substance. Whether your ladyship disregards the answering affidavit or not doesn't take the matter any further, because it needs to be determined on the facts and grounds set out in the founding affidavit, which we can oppose in law and on the basis of record in any event. So there's simply no benefit of or prejudice to the applicant, even if you were to take the answering affidavit into consideration, which you ought to, my lady.
Thank you very much. Thank you for that. Mr. Mathe, would you like to address me on what counsel for the third respondent has informed me?
Yes, my lady. If the matter will be...
Sorry, my lady, might I interrupt? The applicant hasn't got his camera on. It's common courtesy to put your camera on when you address the court.
You're quite right. Please put your camera on, Mr. Mathe. Thank you. And you are on mute.
Oh, sorry for that, my lady. My lady, if the matter is postponed, and I will suffer prejudice because the matter. I also want this matter to be finalized. The only issue I have is that if the answering affidavit was not filed timelessly, my lord, and then you decide that no, there is no need for condonation, my lord, and then I did not address certain things because I did not reply, they will end up in the judgment. So if there is condonation, and then I exercise my right to reply, and then everything is before the court, because my lord, the respondent, since their condonation was out of time, since their answering affidavit was out of time, I did not read it. I still haven't read it. So if a condemnation is granted, I will read it and reply to it, and then the court will have a full picture, because now it's my affidavit, and which I believe is out of time, and that's the only reason, my lord. I also want finality, my lord, but it would not be in the interest of justice that the respondent filed their answering affidavit late, and then I don't get the opportunity to reply to it, and then the matter is finalized without me rebutting or going into the...
I hear you, Mr. Mathe. What counsel for the third respondent has indicated is that they are in a position to argue the merits of this matter, even without the answering affidavit before me. In other words, they can deal with this application on the basis that you have placed it before court. They will argue their position as a consequence. So I'm inclined to do that, because it's very important that this matter be dealt with. Review applications by their nature are urgent. The court has been at pains to make that clear in many judgments. The third respondent, if it is so willing, and I get the understanding that R will argue absent the answering affidavit. And I'm inclined to do that, because in this way, this matter can be brought to finality, and that would overcome your stumbling block with regard to condemnation.
My lord, I've been ready for this matter since 2023, my lord. If we can go to the merits today, we can go, my lord. I have no problem. The only problem was that I would have, if the answering affidavit, we can go into the merits, my lord. I'm ready.
Good. All right. Thank you. Mr. Cook, would
Yes,
you be in agreement with my suggestion?
Yes, my lady, if I could just have an indulgence and just get a final instruction, it's a
Please
proposal
do.
that I've come to. Alternatively, if my lady, if my instructing attorney is not with me on this basis, my lady, we would submit that if your ladyship finds that the answer that there was no need for condemnation, then it's the fault of the applicant that he did not reply. And if he wants to then reply and requires a postponement in order to do that, we'll be asking that this court pay costs. So he must make an election if he wants to. If this court is of the view that condemnation wasn't required and he's insisting on replying, then he must pay the costs wasted today, because he had the option to reply. He took the wrong view. So I'll take an instruction, my lady, but I think after explaining, my attorney will give me the instruction that we can argue it on his papers alone. But I don't want to get into trouble, my lady, without that instruction.
I do understand you need to do that.
Otherwise, yeah,
sorry.
there will be 30 seconds, my lady.
Yes,
they are
thank you.
online.
Thank
Thank you,
you.
my lady. My lady, thank you for that indulgence. I've spoken to both my instructing attorneys in this matter, and my instructions are that we are prepared to argue the matter
on the basis of the notice of opposition. Mr. Cook, sorry.
Sorry, my lady. Did you hear that?
I only caught part of it because then it seemed to go offline. But am I hearing you? You're prepared to argue it?
Yes, my lady. We are prepared to the matter without reference to the
reference to the answering affidavit. Thank you.
Yes, my lady. And we do so in the interest of justice and on the basis that we don't want this matter to be postponed, and that's why we make that concession.
Thank you very much. Thank you. Thank you. Mr. Mathe, I want to understand your grounds for review, please. You've said in your founding affidavit that the Commissioner committed misconduct in relation to his duties and the award has been improperly obtained. I've also taken note of your supplementary affidavit at page 222 of the bundle, where you've made reference to your grounds, amplified grounds, and you gave more content in that regard with specific reference, I might add, to the Commissioner in your mind erring with regard to finding you guilty on a sanction of gross misconduct, but it related to negligence to suit their narrative. Please address me on that, please. You can take it. I've read the papers.
Okay, thank you, my lord. My lord, my grounds for review are quite straightforward in terms of section 140. It's section 145(2) of B that states that an award is not properly obtained. It's improperly obtained. So that for that ground, my lord, I don't have to prove that the award falls within the bounds of reason, my lord. Only the burden here is that is the award properly obtained? So the answer is, my lord, I would like to submit is no, my lord, because what happened was I was given a notice to attend a hearing, and then 4 days before the hearing, I made a request to the human resources. I said, and the proof of this is on the papers. I asked the human resources, can you give me the warnings so that I can prepare for the hearing? And this is in terms of this falls under fairness of the procedure. And she said, no, you will receive them at the hearing. So what that means is that I wasn't given, even though I was given notice that I have to attend the hearing, I was not given the documents that were necessary for me to prepare. And that's also unfair. And the basic conditions of employment at least states that an employee is entitled to inspect any records that relates to them. So that's what I was exercising that right as well. So, and
Mr. Mathe, I want to understand something.
Yes.
You were aware that you had 2 warnings, a written warning, a final written warning for negligence.
My lord, it's not for negligence.
Well, it amounts to poor work standards. It relates to you not conducting yourself in the proper manner.
My lord, the charges there is gross misconduct and gross negligence. So it's 2 things, my lord. So and this distinction is important, my lord, because the test for misconduct and the one for negligence are not the same. And me and the respondent had a contract, and our contract stated explicitly that if I should ever cause the company to lose money, or should ever cause the company any loss, financial loss, the contract states clearly that such loss must be deducted from my salary. And but I will explain. So I'm just giving a context to that too. And then the charge for misconduct is another thing, because misconduct has to be deliberate and all that. So my lord, it's two charges, my lord. And so since the respondent elected to charge me with both things, they had the burden to prove both of those things. You cannot be charged for gross misconduct and gross negligence together. And then when it's time when you get at the CCMA, now they change it. It's no longer gross misconduct. Now it's negligence. It must be the same. And my lord, the case law is clear on this, that CCMA arbitrators do not have the right to adjust the sanction that the employer chose. The employer chose that. So what happened in this case?
Well, Mr. Mathe, I'm going to stop you there, because there is case that indicates that the charge may be framed in a particular manner, but where the facts are demonstrated on the evidence led during the course of the arbitration, if that's not absolutely in strict compliance with how the charge might have been framed, it doesn't mean that it cannot be taken into account. That's the EOH decision, which you seem to maybe not know about. I don't know.
Sorry, my lord, I didn't get you. Can you repeat that part?
It's the EOH decision that I'm referring to. So I hear you, and I've taken note of how you see it, that you see a distinction between gross misconduct and gross negligence. And I'm saying to you, well, if the facts fit gross negligence, well, then I can look at it from that perspective. I'm entitled to.
Okay, so my lord, this is.
I mean, gross negligence is where an employee acts in a reckless manner and shows a disregard for the consequences of their act or omission. There's a significant amount of evidence that I've read in the record which indicates exactly what was happening at the workplace and pointing to omissions by your good self. But I hear you, and I will be looking into this in more detail, because I'm going to give a detailed decision in this matter, but you may proceed further. Okay.
Okay. So my lord, okay. Okay. So this distinction is very important, because my lord, we had a written contract signed by both parties that if I'm negligent, there will be a fair procedure, and then deductions will be made. And my lord, what this fair procedure means, in terms of common law and in terms of contract law and in terms of the basic conditions of employment, is that if maybe, let's say, you work at KFC and then you cost the KFC 40 Rand because you sent a wrong order to the custom. In the fair procedure, they want you will come down for a fair procedure, and then they will say, okay, you know what you did, and then maybe you did it on purpose or whatever. So what will happen is that they will say you've costed the company $40, but since you work in the company, they have to take out maybe $20 for manufacturing and all that. But that's not what happened. So if I was dismissed for negligence, for being negligent, then they did not follow a fair procedure. And also, my lord, the respondent did not prove that I caused the loss, my lord, because there are a lot of allegations there that were never proven. And I did tell the arbitrator that the chairperson was biased there. And then when you say that someone is biased, my lord, you have to explain why do you say that, and then the arbitrator must apply the bias test. There is a test for bias for biasness. He did not apply it. He simply took the respondent words for it. She said no. She just denied it. She said no, I was not biased, and then he simply recorded it and took it as a fact.
she actually said that she knew nothing about your matter before she was seized of it in your disciplinary hearing. But it doesn't seem to be in the award that was issued that you seriously contended this issue of bias.
Oh, okay, my lord. I did tell her. Okay, I did tell her at the hearing. I told after I requested the documents to prepare for the hearing, and they refused. At the hearing, I told her that I didn't have time to prepare because I didn't have the warnings, and she said to me, "I'm not here for the warnings." So that indicated to me that okay, she's not here to hear the matter; she's here to decide. You see. So what happened was I went to at the CCMA, the arbitrator and her. They misled me. She said, "No, I'm here as a witness because I was a chairperson." According to the law and my knowledge, you can't be a witness, but you are a witness that leads evidence, that cross-examines. And then I knew that those were roles that were reserved for legal representation. And then, because this matter was for misconduct, the respondent were not entitled to legal representation. And then the respondent were given a representation unlawful and against Rule 25 of the labor of the CCMA rules. And my lord, it should not be a burden that when we go to the CCMA, we should expect that the CCMA, that they don't know the rules of the CCMA.
Mr. Mathe, are you're referring to Miss Esther de Beer?
Yes.
She's an executive member of the General Domestic and Professional Employers Organization, and she appeared in that capacity. This is not a situation where she was appearing on any other basis.
My lord, you cannot be today. You cannot preside on the matter and be a judge, and then on appeal you appear as counsel, and then you say no, I was impartial because I was a judge that day. Today I'm here to advance the matter of the respondent, and then the bias test is not evident that you are indeed biased. And my lord, if it was made clear to me that she's not there as a witness and I was not misled, I would have said I object to her being the respondent being allowed representation. I would have went and sought my own representation if that was the case. Because, my lord, I also was entitled to legal representation if there was an application. They did not make an application in terms of Rule 25 because the matter was in terms of misconduct. That's what the employer charged me for and dismissed me for misconduct. And when I filled out my 711, I did it correctly. I looked at what I was dismissed for and it said misconduct. I did state, okay, this matter is for misconduct. And then I went down there. It asked, does this matter have to do with discrimination? I said yes. And then once you mentioned that the matter is in terms of, there's also some discrimination involved. When the matter comes before the arbitrator has to adjudicate the matter in terms of what it was applied for. It was a matter of misconduct, and the respondent there were given representation in the rules that she was a witness. You can see that this was done deliberately to mislead me. And my lord, and the other thing about the warnings, my lord, I raised the issue with the warnings at the disciplinary hearing that I did not receive them, and can we go into them because these warnings are fraudulent. And then she said, no, I'm not here for that. And then we got at the CCMA there, and the CCMA commissioner, when I tried to go to the warning, he said, no, it's too late for the warnings and all that. And then when he said that, I asked myself, how is he going to write the award? When he wrote the award, he made a reference to those fraudulent warnings that I wanted to address. So, my lord, that's called a surprise judgment. You cannot say today, I will not refer to the late answering affidavit, and then on your judgment to refer to it. It's unfair because I did not address it. Because if he said, okay, we're going to go to the warning, I was going to prove to him that those warnings were fraudulent, because some of the warnings, they said I was given at June. The one he referenced there, if you check the date there, that warning I was given 2 days later. 2 months later, I mean, all those warnings except one is actually correct. The other ones are incorrect, my lord.
I hear you. Thank you.
And my lord, there's also a case law. My lord,
Go
yes,
on.
my
Yeah.
lord.
Yes, please go on.
My lord, when it comes to because I knew that the disciplinary hearing was I knew that the warnings were manufactured and the charges. So, and the disciplinary hearing was also compromised. When I went to the CCMA there, I also saw that no man, this commissioner is also compromised. So I recorded the proceedings with my phone in case the records are destroyed. And my lord, when I applied for this review, the records were incomplete. And my lord, I want to submit that it's not coincidence that those records were incomplete. It was deliberate, but because I knew what I saw there, that no, the records are going to disappear, I recorded them with my phone. As a result, this court has the entire record, despite the CCMA arbitrator destroying them. So, my
But
lord,
we have a complete record of the evidence. You filed that.
yes, I filed everything.
Thank you. Thank you. You filed everything. I've seen it. Thank you.
My lord, and the other thing is, I want to say this. I want this court to apply this. The law is that if the reason for dismissal is hidden, it is the duty of the court to find out why is the reason for dismissal the hidden one. People, in this case, my lord, the applicant was dismissed for discriminatory reasons, amongst others that the applicant is black. So that's why they had to call in Mr. Esther De Beer there to hide the unfairness of the dismissal. So my lord, when I would ask the court to exercise its powers to determine the true reason of dismissal, because my lord, it was actually not the stated reason. And I did state the reason that in the affidavits there, that the reason stated on the reason stated on the dismissals are not the actual reasons. So my lord, it's for other reasons. So my lord, when we were at the CCMA, my lord, I saw those fraudulent warnings, and the warning stated that I was employed as a lab technician. So my lord, this is very important because I was employed as a lab technician, and as such, I was compensated as a lab technician. However, the warning state that I was a inspection technician. So I got, when they responded, I was happy that I got the respondent under oath there. So I asked him, the complainant actually saying something. So I asked him, what is my job title there? It's also in the transcript there. And then he said, no, inspection technician.
I've read this. Thank you.
Or he said inspection technician. So
No.
that, sorry?
Yes, I've read that. Yes.
So that proves two things, my lord, that they varied the employment contract, and that change was not in writing, amongst other things. And because, my lord, when you are accused of causing loss to the company, my lord, the respondent has to prove that you caused the loss to the company and that they did not contribute.
Well, they had a customer that complained. And the test for whether an employee has brought the company's good name and reputation to disrepute, all right, isn't it? It's an objective.
Sorry, can you repeat that, my lord?
The issue with regard to bringing the company's name into disrepute is tested objectively. And in this matter, there's a customer that was extremely unhappy. Extremely unhappy. Surely I'm entitled to take that into account.
Okay, so my lord, there is evidence that there was a customer that was unhappy, my lord, and so the unhappiness of the customers has to be determined who's at fault here. So, my lord, I would like to submit that it's not the applicant's fault. The respondent did not train the applicant, and the applicant provided training, provided proof that he was not given the training, because the applicant was hired as a lab technician, and then the respondent unilaterally changed him to another department without giving. When the applicant started working for the respondent as a lab technician, he was not giving the training was not completed. So there are things that the applicant didn't know, and he was moved to night shift, and the night shift has no supervisor there. So there's no one to supervise the applicant. The applicant is not given training. The applicant is in a different department, given a new role, and then he makes a single mistake he did not know of, and then that results in the unhappiness of the customer. If the respondent did their job and trained the applicant would have done the right thing. And furthermore, the applicant, it's on the records there, he asked the employees that also work on the night shift that if he did know about this particular custom, and the applicant and those witnesses confirmed that no, the applicant did not ask, because when that customer was unhappy, one of the managers came to the applicant, came to the department and asked the applicant if he knew about this, and the applicant told him he did not know, and those people who were to witness were also there, and then they also confirmed that no, the applicant did not know. And then there's also an issue of so that, my lady, is not the fault of the applicant, it's the fault of the respondent. The respondent unilaterally changed the employment and then did not give training even before the change. So the applicant did what he could. If the respondent did as they were required to do, completed their own training, because the training that the applicant had to know, because when the applicant came, he came with some experience, but that experience was specific to that company. So when you get a new job, my lady, maybe you move from the High Court in Cape Town to the one in Johannesburg. When you get there, my lord, you have to be shown that, okay, this is how we do things here. You can't be expected to apply the same things, but if you are not given the training, you are going to do the things that you were doing in Cape Town. So this is what happens here.
Mate, are you Mr. Mate?
Yes, I am him.
Because you keep calling yourself the applicant, he.
Yes,
I
my
wanted
lord.
to just make sure that you are indeed Mr. Mate. Thank you.
Yes,
It's interesting that on the question of the warnings, that was canvassed in the arbitration before the commissioner. And the warnings, you actually agreed to the two that were being referred to and relied upon by the third respondent. You agreed.
No.
Have a look at your page 304 in the transcript.
My lord, I did not agree to those warnings. My lord, what happened was those warnings, the commissioner said he would not refer to them. So I did not agree to anything. What I said was, the first warning was given and I did not sign it because it was fraudulent. And what happened then was retaliation, and so much retaliation that it resulted in dismissal, my lord. So what happened was they gave me a fraudulent warning that stated that I was given intensive training out of all things, while I was given zero training there. And
it's strange to raise that, because one of the witnesses you called in your defense, right, at the CCMA supported the company's contention that it indeed trained its employees.
Okay, my lord, when you go to the CCMA, you don't go for broad things. You go for specific things, and things that have to be proven are not broad things, are specific things. I asked the respondent didn't prove that they gave me training. They said Derek gave training, and the respondent doesn't have an employee called Derek. So I was never given employee training by Derek because he does not exist. It's one of those manufactured things. The respondent even manufactured people there after manufacturing charges there. My Lord, I was not given training. There's no one who was there when I was given training. And I have proof that I was not given training. So how can I be given training that I'm not aware of? And there's one of the witnesses that they were given training and they went in twos. So if that was the case for me as well, there would have been someone that I went with there that would have say, me and Joseph were given training by such and such, but there's no such person.
Thank you, Mr. Mathe. Obviously, you must appreciate that I am seized with this matter on review. A review is not an appeal, all right? And you must understand there is a distinction. So I am required to look at your grounds for review. Are they grounds recognized for the purposes of Section 145 of the Labour Relations Act, suffused with the test in Sudumo about whether or not this is an award that a reasonable decision maker could have reached? And I hear you on what you had to say. I asked you to address me on the grounds for review. You've given me your submissions in that regard. Is there anything else you would like to raise?
Yes, madam. I want to say,
but it must be within the confines of your grounds for review. I'm not here to re-examine every facet of the facts, because this isn't what a review is about.
Yes, okay, yes, my lord. I want to address you on those things, my lord. Can you just give me a moment? I wrote this down. Okay, so my lord, I want to submit on this. There's a case, Herhold versus Nedbank.
So I'm aware of that decision, Nedbank. Yes,
yeah,
I know
that the test for reasonableness does not extinguish procedural grounds of review. So my lord, in this case, as I've stated, that it was in terms of 145.2 that the award was not properly obtained. So it's about.
You've addressed me on that. I understand.
Yes, I want to address you on the defects. So, my lord, when it comes to the defects, it's not that the defect is small. It must be a huge defect that renders the award improper or improperly. So, my lord, the first thing is when I address that is that okay. So since the Sidumo does not replace this test that this application is on, is that did I get a fair hearing at a disciplinary hearing? I did not, because I was given the notice. However, you can be given a notice of 6 years to prepare, my lord. But if you don't have the documents that you have to defend, you are not given. That's procedurally unfair. And then at the CCMA, my lord, I was misled, my lord. It's said that I have to be misled by an arbitrator and say, no, this person is a witness, but well, in fact, they are a representative. So
I make note of it. I think I've got your points on that front.
Okay, so
thank you. Please don't repeat yourself, because there's no utility in doing that.
Okay, so and the other thing, my lord, is that me and okay, I've also stated something about the ability between me and the respondent's ability.
Yes, I've taken note of that as well.
Okay, and then I want to give me a second, my lord. I want to, And also, my lord, I don't think the documents that I submitted to prove that I was not given training on the file. I don't have the induction document. I don't have to address it, do I? Because it's in there and it's unsigned, my lord. Or should I address it?
No need for that. Thank you.
Okay. So, and then I must go and go and go and go. Yeah, and also, my lord, when we were at the hearing, the commissioner said this matter is in terms of Schedule 8, and then when you look at the arbitration award, my lord, he does not refer the Schedule 8. Schedule 8 there. That means he did not apply it, and it's evident from the paper that he did not apply Schedule 8. I don't know what he applied, and then what else? I want to see.
Okay, I think I've got your points, and unless there's something that is absolutely critical you need to raise with me, just understand that I have your heads, and I have the record, and I have the bundles, and I have the
Yes. Yes, give me that. And also, my lord, there's also I'll also like to add the part of unfair labor practices, my lord, because
No. With respect, this matter is before me, and it has to do with an unfair dismissal. I'm not here to adjudicate an unfair labor practice. I'm sorry, that's not within my jurisdiction in terms of this particular matter.
Okay.
Okay. Thank you.
Okay.
Are you done, Mr. Mathe?
Yes, my lord, I'm done.
Thank you. Thank you very much indeed. I've taken note of your submissions. Mr. Cook?
Thank you, my lady. I don't know if your lady is going to take a tea break because I know it's 10:56. I'm quite comfortable proceeding, and I trust I won't take too long if your ladyship wants him.
I would be extremely pleased if you went straight ahead.
Thank you, my lady. I shall do. My lady, it's quite clear from your interaction with the applicant that your ladyship has read the papers, so I'm not going to flog a dead horse in this matter. Your ladyship is aware that this is a review and not an appeal. Your ladyship is fully aware with the principles in Sodoma, which have been crystallized through the years. The test ultimately is the decision of the commissioner, one that no reasonable decision maker could have made on the evidence properly before that commissioner. It is abundantly clear after reading the papers and hearing the oral submissions that the applicant hasn't demonstrated to the court that the award is unreasonable. Could I also ask the applicant to switch off his camera and
yes, of course. Mr. Mathe, you can take yourself off.
And also there's a guest here by the name of Court Regalki. If they could also switch off their camera, please. Sorry, my lady.
Yes, sure. I'd like that other person, please, to switch off that camera. I'm not aware that they're meant to be in this hearing in any event. I can't see.
It's for the record purposes, my lady. I don't want an interruption. If you could. Thank you, my lady. My lady, the grounds of review are not sustained. You'll note that there are no references to the record. There are a couple of important things that I need to just bring to your ladyship's attention. Firstly, my lady, if we go to the combined bundle that was produced by the applicant, which we submit, is not in accordance with the rules, but be that as it may, on page 1, pro forma notice of motion was filled out, and it's quite important for your ladyship, in the unlikely event that your ladyship were to find that this matter is reviewable, the relief that is sought in the notice of motion is only that the matter be remitted to the CCMA. And the reason why that's so important, my lady, is obviously if the reinstatement or retrospective reinstatement were to be sought, I wouldn't be so brave as to just argue this matter on the papers as they stand, because as you would know, we'd have to show why reinstatement would not be appropriate. And if there ever was a case, my lady, for a matter that where reinstatement wouldn't be appropriate, we would submit that this is the case. You could hear from the absolute disdain, the way the applicant addressed the court in respect of his erstwhile employer. There is simply no trust relationship between either parties in this matter, and therefore a reinstatement, even if it were to be asked, would have been totally inappropriate. What I've noticed, and from the papers in relationship, there is simply no remorse demonstrated by the applicant in this matter. The applicant has come to court after years of reflection, after being unemployed and had time to reflect and to cool down, has not lost any of the fire and rhetoric attacks on the employer. He used words like, "It's because I'm black, my lady," in the address to the court. That's why I was dismissed. He says that the charges are fraudulent, that these aren't the true reasons for his dismissal. So there's simply no remorse. So in the circumstances of this matter, when there were counseling, there were a written warning, a final written warning, a disciplinary inquiry for the same offences. Now, if you could just go briefly to the warnings, my lady, they're very shortly on page 67. This whole issue, the confusion that is trying to be created about why was he dismissed. Well, it's quite clear why he was dismissed. At page 67, you'll see is the first warning, which was valid for 6 months, was issued in December 2022. It says there, misconduct, including negligence. Okay. So what was classified is what you were doing is misconduct, including negligence. Now, as your ladyship is well aware, there's a distinction between misconduct and poor work performance. What the employer is saying is that you know how to do this job, but you're failing to do so. You're being negligent. It's not that you can't do the job or you need the training. You are being negligent, and negligence is a form of misconduct. So, my lady, if we go then to the final written warning, which is on page 79, yet again, it says misconduct, including negligence. So that is what he was dismissed for. Negligence is a form of misconduct. He wasn't dismissed for poor work performance. And the reason why he wasn't is, in his own words, he says that when he applied for the job, he was a perfectionist. He also, in his employment contract, held out that he warranted that he could perform his duties, bearing in mind that he came from a competitor and he boasted that he had years of experience. So this is not a matter where it's about poor work performance or lack of training on what he could do the job. And more importantly, he's been duplicit in his approach to this matter, because in his defense, he's saying, but I only made a few mistakes. Now, if you're only making a few mistakes, why, that is clearly demonstrating that you can do the job if you want to. It would be different if he was making thousands of mistakes, because that would be indicative of the fact that he didn't know what he was doing. But the fact is, in this matter, there was concrete evidence led through the witnesses of 11 concrete examples of gross negligence in this matter, where he should have and didn't follow what he was meant to do. That was objective facts that were put before the commissioner. The commissioner took that into consideration. But more importantly, in the evidence and in the transcript, and on the transcript, they said these are not the only incidences. We only could put so many of these incidences before you. These are just a sample of the mistakes he's making, the negligence, my lady. So those are the tip of the icebergs, but they were sufficient enough, they were consequential enough to demonstrate that he was being negligent and that it had consequences on reputation as well as financial. My lady, right throughout this matter, the applicant has denied any responsibility. He starts off by saying that he entered into the contract of employment under, he was forced to sign it and he was misled to it. He then says that he wasn't aware about the disciplinary policy or procedure. I can hear him talking from that person, court guest. Please, could you mute yourself? Mr. Hurricane Gory or whatever, Court Hurricane Gory, you're on. Not on mute.
Thank you.
Thank you. It's going to make the record. Thank you very much. My lady, excuse after excuse after excuse, no accountability. He says that he didn't get the disciplinary code of procedure, but despite the fact that if one has reference to his contract of employment, it references the contract, the disciplinary code, and he binds himself in his contract of employment, my lady. If one has to cite on page 153 of the bundle, it says in paragraph 4 of the contract of employment that he entered into, he says, I'd adhere to the conduct as well as the disciplinary procedures and policies. But my lady, regardless of whether he knew, and the evidence is quite clear and quite probable that he must have known about the code of policies and the disciplinary code, even if there wasn't a code, and even if he didn't know, we know in labor law is, did you know about the rule or standard, or should you reasonably have known about the rule or standard, my lady? So it doesn't actually make any difference whether he received a copy, which is denied, and the other witnesses said we also received it, and the commissioner made a finding in that regard, which is reasonable. My lady, he constantly looks for excuses and doesn't take responsibility and blames and points fingers at everyone instead of asking himself why he lost his job. He comes up with conspiracies. Everyone's against him. My lady, one of the things, and I'm going to move on as a motivation for the discretion in this matter of costs. My lady, there is a very scurrilous, scandalous, and vexatious accusation made against the commissioner and the representative of the third respondents that they conspired and met. Now, the reason for that, my lady, is he says, well, I caught them red-handed. I have a recording of them talking about getting together to conspire. But if one goes to that transcript, my lady, it's in the record, which he places reliance on. All one can see, my lady, is that what they were doing there is that the commissioner and the representative were talking about the matter being part heard and the fact that they needed to arrange dates and she was flying away. There is simply no basis to say that they were conspiring and colluding. As I mentioned earlier, my lady, this applicant needs to learn that litigation is not a game, that litigation has consequences. He has launched and caused the respondent to come to court in another urgent application in the High Court. But more importantly, he has taken the CCMA as well as the commissioner to the Labour Court seeking damages and seeking that they be investigated by the National Prosecuting Authority, making scandalous, unfounded accusations without consequence. We submit, similarly, the way he has conducted himself in this matter and caused the third respondent and the court the unnecessary expense of what we would submit is a review application that is simply without merit. It's ill-conceived and should never have brought before the court. And on that basis, your ladyship knows that despite the Zunga principles, that this court has discretion in terms of 162 to make an order as to costs take into consideration law and fairness. And one of the considerations that your ladyship would take into consideration is the conduct of the parties in the matter or in proceeding with the matter. Now, your ladyship, this is a review that is meritless. It is completely meritless. And on that basis, it should never have burdened this court or the third respondent. And there are simply no grounds that are justified or sustained, despite being given an opportunity to file a supplementary affidavit. So we would submit that this is the most appropriate case for this court to exercise its discretion and to order costs against the applicant for bringing this meritless application.
Mr. Cook, there is a point that I'd like to raise.
Sorry, my lady, you're a bit faint.
Okay.
I can hear you now.
Point I'd like you to address me on, if you don't.
Yes, my lady.
And that is his complaint that the person that was involved in the disciplinary hearing,
yes,
chairperson, came to represent the employer in the arbitration.
Yes, my lady. I often represent the employees in matters, and often, as a matter of course, what happens in these things is the chairperson, they chair the disciplinary inquiry, then they represent the individuals at the CCMA. And then there's the accusation that they were impartial. It happens invariably, but that's not an indication of impartiality. If one goes and looks as to why he said the commissioner, the chairperson was biased, in his own papers, if we go to 118, you'll see the basis for that is at page 118. It says, I believe that the chairperson, it's in the middle of that page, my lady. It says, I believe that the chairperson of the disciplinary hearing was biased because she says she would not go into warnings as they're already done. But during the hearing, she went into the warnings, one in favor of the company. She says that. So the basis for him saying that she was biased was because she said she's not going to go into the warnings as they're already done. Similarly, as the commissioner did at the CCMA said, but you didn't object to these warnings. You didn't challenge these warnings. The horse is bolted. We all know, my lady, when it comes to warnings, the law is clear on this, is that if you have a difficulty with a warning and you think it's an unfair labor practice, you are duty bound to challenge it. You can't let the warning sit unchallenged, and then when it's used against you.
I understand.
Yeah. My lady, just on that point, my lady, he says that he was he was deceived as to the representative. He thought he was a witness, but my lady, I made note. I think it's on page. If I can just get the attendance registers, my lady. If you look at the attendance registers that form part of the record, it clearly designates the individual whenever she appeared in the capacity as a representative, not as a witness. But if he was confused, he said he would have objected to the person because if he'd known they were going to he would have objected. Well, there would have been no basis for the objection. We all know what Rule 25 says in respect of representation at the CCMA. In her capacity, she had the right to represent the company, and she did so, and she was entitled to do so. So in terms of Rule 25, she didn't appear as a legal representative, but as a representative of an employees' organization, and therefore she was entitled, and the commissioner committed no irregularity about allowing her to represent the third respondent. But if we were to accept that he was confused or misled by her capacity and he thought she was going to be a witness, well, when she started leading the evidence or making opening statements, my lady, he could have and should have, if there was a basis to object, to say, no, I'm objecting to you on whatever basis. He elected not to do so. And one thing is for sure, you've heard the address from the applicant, he will never be accused of not standing up for his rights. And he certainly, if he wanted to, what did the commissioner do wrong? And in any event, I don't fail to understand on what basis he could have objected to her representing the company. On what basis? You can't tell the other side who can represent them if they're entitled to be represented. So, my lady, there's simply no substantiation, and your ladyship knows very well the difference between appeal and review, and you cannot simply make generic statements in a review that were not supported by the record, not supported by references, and ask the court to be a truffle pig and look for the truffles in the record. That's not the duty of the court. The applicant must stand and fall by his founding paper and supplementary affidavit, and simply he hasn't done so. And that's why we are confident to say that on his papers as they stand, he hasn't made out a case for the relief. In the circumstances, we ask that the review application be dismissed with cost. We leave the scale to the discretion of the court. But justice will only be served in this matter with respect if the applicant learns that litigation is not a game, that you don't incur unnecessary costs and burden the court with a frivolous application that is littered with vexatious, scandalous, and of perjury, of colluding, all these accusations which are not supported by the record. The facts of the matter, if you look at the disciplinary record, at the disciplinary inquiry, he admitted he did certain things wrong. He admitted that failures. In those circumstances, my lady, dismissal was appropriate. Progressive discipline had been applied, and he now turns around and says, it's because I'm black. It's not the true reasons. And my lady, with respect, it's 2025. Those sort of accusations are serious, and you don't just go back to, with respect, the race card. I was dismissed because I was black. There's no support of that. And my lady, if that was a fact, he would have had to launch an automatically unfair dismissal case, which he didn't, and he never mounted that case. He's now saying, after a commissioner who did their job, listened to the evidence, gave everyone an opportunity to hear, came to a conclusion, and now he tries to justify it by saying I was dismissed for other reasons because I'm black. It's simply unpalatable.
Judge Davis did say in Timothy versus Nampak Corrugated that where there is no appreciation of wrongdoing, very difficult in those circumstances
Remorse.
to come to the assistance of the litigant unless there is a scintilla of remorse. And I failed to see that on this record.
Well, my lady, you see the complete opposite. You see somebody that has done nothing wrong. He goes on record to say that the warnings, which he didn't challenge, are fraudulent. He goes on to say that this is not the true reason why I've been dismissed. There is simply a lack of appreciation for any wrongdoing in this matter. He has done nothing wrong. The world is against him, and it's a conspiracy, including, as I said, my lady, taking the CCMA and the commissioner to the High Court to say that they must pay punitive damages for grafting, my lady. They must be prosecuted for that. My lady, this is unacceptable. With respect, and I don't want to stand on my soapbox, but the difficulty when the courts, like the Labour Court, allow you to fill out a pro forma review, like in the CCMA, and litigants think, well, I can just put whatever I want down on that and roll the dice, and there's no consequences. It's not acceptable. This has real consequences. You don't make these accusations without foundation, and you don't expect to launch applications without consequence, my lady. So, my lady, the Zunga principles are not applicable in this matter. This is a matter, and there's a long line of precedents that this sort of conduct should be met with the appropriate cost order, my lady, as the court pleases.
Thank you very much. Thank you. Mr. Mathe?
Yes, my lady, can I address what the respondent has raised now?
I want you to address me only on very specific points, because I've heard you in argument initially, so I will ask you not to repeat that, please. But you're welcome to address me on the issue of costs. Mr. Mathe, you're on mute.
Sorry, my lord, you said I must not repeat myself and then address you on the issue of cost. I'm
saying to you that don't repeat what you've given me in your opening address, because I have those points. All right. Okay. Yes. What comes out of Mr. Cook's address, anything there that's new, then you may address me. He has addressed me on costs, and you have a right to address me on that issue as well. Thank you.
Okay, my lord. When it comes to the review application, the grounds that are stated there are when it comes to the notice of motion, the relief sought is not drafted by the applicant; it's done by the court, my lord. Even it's a template that I received from the court to fill out. So I filled out as it is provided by the court, the relief sought there. So, my lord, I don't think it would be in the interest of justice to simply remit the matter back to the CCMA, because it was there and then it took 2 years for this matter to get here. So if it goes back to the CCMA, it will take another 2 years for it to come back here. So, my lord, it would not be in the interest of justice that the matter is simply remitted back to the CCMA. What I actually seek is that this court gives an order that it deems fit and fair under these circumstances, because simply remitting it back to the CCMA would not even cause finality to the litigation. And my lord, when it comes to the issue of remorse, my lord, when you did something, my lord, upon close retrospection, you do look at yourself and then you say, did I do this? But my lord, I did not do what I was accused of doing. And so I cannot be expected to say, no, I did not do this, and at the same time display remorse, because I did not do what I said I did. So, my Lord, I did not do. And my Lord, the respondent says...
Mathe, your case is that you didn't commit wrongdoing.
Yes.
Yeah.
And at least in the list, it was because the respondent did not give me the training that they were supposed to give me.
I made that point. I've got that point. Thank you.
Okay. So, my Lord, the part when they say that I admitted things on the disciplinary outcome, my Lord, should not be written as if it's written by an angel, my Lord. That I did not agree with the findings on the disciplinary hearing. I did not admit anything. I did state that the witnesses did not want to come to testify. And then when I was at the CCMA, I had to subpoena those witnesses there.
That's fine, but you had your opportunity of a rehearing in front of the commissioner. You had that rehearing and you led evidence in your own defense, and you obviously led your own witnesses too. I understand that. I've read the record.
Yes, and at the CCMA, the commissioner said I wasn't allowed to cross-examination to cross-examine the witness, but he also allowed the respondent to cross-examine witness, but that same was not extended to me, because when the complainant was giving evidence, I did ask the commissioner will I be given an opportunity to re-examine, and he said no. But when one of the subpoenaed witnesses was before the commissioner, the respondent representative did not even ask for re-examination. He asked them, it's on the record there, when he asked, do you want to do cross-examination? And then he extends what he refused to me. And my Lord, there are a lot of omissions in the award, in the arbitration award. Amongst others is the fact that the witnesses were not there on their own accord. They were there because they were subpoenaed. And one of the witnesses
There's no issue with the subpoenaing of a witness. That person brings that person before the forum in order to testify.
Yes. And also, my Lord, I would like to say this. The respondent likes to refer to things that are not before you, things like at the High Court and whatever. My Lord,
I'm aware of that point you're making there, because that information is not before me other than what was said this morning, and I am going to be constrained by the four corners of this record. Okay,
thank you, my Lord. My Lord, one of the benefits of me being here is that I was there when on the first day of the arbitration, my Lord. And what happened was when we were one of the witnesses, Chris, was supposed to testify on that day, but then he asked the commissioner that he is supposed to go and fetch his daughter.
Objection, my lady. I'm objecting.
I don't think this has any relevance to your grounds for review, Mr. Mathe.
And he, as you just stated, he says you need to confine yourself to the four corners of this record. He's not here to testify.
Okay, I apologize. Okay, so my Lord, let me move on to the other thing. My Lord, the other thing, when it comes to the conduct of the parties, my Lord, I complied with the rules of this court to their entirety, all the time, back to back. The respondent did not, the CCMA...
This has absolutely no relevance to what I am asked to decide.
Okay, so my Lord, the other thing I would like to say, yes, the chairperson on the disciplinary hearing found me, she said she found me guilty of gross misconduct and gross negligence, but at the CCMA, she changed what she found me guilty for, and she was under oath when she said, it's even on record when she says, no, the applicant was dismissed for gross misconduct, but that's not what she found me guilty of. So, my lord, you can see that it's inconsistent. And also there's something called...
Mr. Mathe, you made that point in your opening address. I've already got a note of that. Thank you.
Okay, so my lord, I would also like to say this. I did indicate, if you look at the bundle from the CCMA compliance bundle, it shows you the documents that are there, the LRA 711 and all that. Yeah. If you look at that, my lord, you will see that there's a document called document number 10. It's called Disciplinary Code of Procedure. You see it?
Yes.
The reason that document is not part of the document, it's because it was not at the hearing. It was produced at the CCMA. We had to postpone for it to be produced. It was not at the hearing, my lord. And the arbitrator makes reference to it at the award. He said the applicant had sight of this document. I did not have, and it was not before the disciplinary hearing. And it shows even here that it was not part of the document. That's why it's alone there. It's one document that came in. It was not part of the bundle of the respondent. So I'd like you to note that, my lord.
What about the issue of costs, Mr. Martin?
My lord, I think I also want cost, my lord, I also want cost, my lord, because there are costs in the cost that I paid, my lord. I think I'm like everyone else, I'm entitled to them as well, my lord.
Yeah. Thank you. Is that it?
Yes, my lord.
Thank you very much. I will give a written judgment in this matter, so this matter will be reserved accordingly to allow me the opportunity to do so. Thank you.
As the court pleases.
Thank you very much. Thank you.
Thank you.
Can we proceed with the next matter, please?
Judge, Mr. Sneeman for the next matter is in court on another matter. I'm not sure if he's on now. Oh, no, he's here. All right, calling case number JR1472-23, Mjaju Joseph Mathe versus Hoya Lens South Africa.
Thank you, Mr. Sneeman.
Thank you, Malady. I mean, what matter is called? I'm here for route management.
Correct. Route management. Correct.
Route management versus routes on behalf of it. I'm for the applicant, Malady. Thank you.
Yes. Thank you.
My lady, Polisangago appear on behalf of the third respondent.